Good afternoon, folks, and welcome to the second edition of Facebook Live, straight from my office here in Alexandria. Today I'm joined by Amanda Curatori, who is a Senior Workplace Relations Consultant from FCB Group. FCB Group are the lawyers who provide human resource advice for all of our members. Amanda's going to discuss some common HR questions we've been receiving and to answer some of the more difficult ones to understand. So thanks for joining me, Amanda. As all of our gyms now across Australia are getting ready to reopen, let's talk about how we can get our employees back to work. So the first question I have for you is, if I have stood someone down from work, how do I reinstate them? Is there a formal process?
Yeah, thanks, Barry. I'm really excited to be here today. So in response to your first question, there is always a formal process, and getting your employees back into the workforce it is also a process that you need to follow. So the very first step is you need to identify whether they've been stood down pursuant to a Section 524 stand down under the Fair Work Act or pursuant to a JobKeeper enabling stand down direction. Either way, you'd need to give notice, consult with your employees and let them know that the stand down period has now ceased and that you'll be requiring them back into the workforce.
Okay, while they've been stood down, Amanda, do they continue to accrue leave?
Yes, they do. Absolutely.
And can I transition someone from full-time or permanent part-time to casual when I bring them back on board?
The answer to that is no, not unilaterally. You'll need your employee's consent to transfer them from a permanent employee to a casual employee. What you can do, however, is that through if your business is JobKeeper qualified, with a JobKeeper enabled stand down direction, you can reduce an employee's hours of work if you don't require them to work their full-time 38 hours per week. But to unilaterally change from a full-time or part-time to a casual employment, you do need your employee's consent.
And in the unfortunate situation while they've been stood down and when they return to work, what do I do if one of my employees actually contract the COVID-19 virus, or we think they have?
Whether they contract the virus or whether you think that they may have the virus are two separate different things. So we'll talk about both of them. So if they actually have a confirmed case of the virus, then they'll need to follow the government directions in relation to that. So currently, I believe it's still an isolation period of 14 days. However, if you believe that they may have the virus, or they maybe will just simply have symptoms showing, flu-like symptoms, which indicates that they may have the virus, then what you can do is ask them to attend a doctor and provide a medical certificate certifying that they are actually fit to work. It's important to remember that when you do that, because the direction is coming from you as the employer, directing them to take a period of time off or to attend the doctor, that this must be time that you must pay for, including whether there are any fees associated with attending the doctor's appointment. It's only if the doctor's certificate certifies that they actually are unwell, whether it be because of the coronavirus or just a normal common everyday flu, then they can transition and have that period into as remunerated as paid leave, personal paid leave, that is.
And would you recommend that if I direct or request the staff person to go and get themselves checked for the COVID-19, that I also request that they come back with a statement from the doctor, or is it okay for them to come back and just verbally report what they believe the doctor said?
I guess it depends on the situation and the circumstances. If it's an employee who, as I said, is exhibiting the flu-like symptoms and you are genuinely concerned that they may have the virus, then absolutely get the statement from the doctor.
Okay, and in the worst case scenario where they may have to self-isolate, how is that period of that self-isolation treated from an HR point of view in terms of leave and so on?
Yeah, absolutely. So if it's because they actually have contracted the virus and they are actually unfit to attend work and they are unwell, then this will be a period of paid personal leave. If they are simply isolating upon the government's direction and initiative, and they're not actually unwell, but nevertheless need to self-isolate, then under the Fitness Industry Award, there's been a newly inserted provision allowing for unpaid pandemic leave. So this gives an employee to utilise 2 weeks of unpaid pandemic leave. So it will be at that point unpaid if they are fit and healthy, but do need to self-isolate upon government direction.
So if they do have confirmed by the doctor that they have COVID-19 and they're in self-isolation for, I think it's 14 days or whatever, and their accrued sick leave doesn't cover that period, covers part of or whatever, or none of it, what is it? Are they then on unpaid leave, or what's the story there?
That's right, unpaid leave. So just like any other normal circumstance, if you are genuinely unwell and unfit to attend work, you can utilise your paid personal leave balance. When that is exhausted, then you transition to unpaid leave.
And what happens if, as we know at the moment, many workplaces are starting to return to work? What happens if an employee refuses to return to work? They don't have the virus. They're just worried about their own circumstances.
Yeah, this is a very, very common question, and I guess it needs to be answered on an individual basis, because we do genuinely need to consider all of the circumstances. One employee is going to be different to another employee, and their circumstances will vary. Some might have genuine concerns. They might be a vulnerable person themselves. They might not have the virus, but they may be a vulnerable person to the virus, or they may be the carer of a vulnerable person and therefore need some special consideration. But putting those factors aside, if it's just, for lack of a better word, normal employee who's not considered a vulnerable person, who is refusing to come to work, if you are JobKeeper qualified, that is, you can direct them back into the work. So as we discussed previously, you'll be ceasing the stand down provision and then making a direction pursuant to the JobKeeper enabling stand down provision to have an employee work reduced hours, or maybe it's full-time hours depending on your needs. And if they do not follow that direction, again, bearing in mind all of the circumstances of the case, it may be that it will end up in disciplinary action of the employee not following a lawful and reasonable direction of the employer.
So just to clarify that, there has been a number of stories in the media where particularly some part-time employees are earning more in the JobKeeper, and they're refusing to return to work. So you're saying under those circumstances, the employer can direct them to return to work, and if they don't, disciplinary action can be brought into play.
Yeah, that's right. So you can direct employees to return to work. In the instance where a part-time employee works less than $1,500 per fortnight and you're wanting them to work increased hours to meet that amount, you may ask that an employee picks up extra shifts. However, you cannot direct an employee to work in excess of their ordinary contracted hours. So maybe to be clear on that, if you have a part-time employee who is contracted for a minimum of 10 hours a week, and they are on JobKeeper, they're getting $1,500 a fortnight, their 10 hours of work a week is less than what they're actually receiving under JobKeeper, you can ask them to work 15 or 20 hours in a week or in a fortnight, and they will need to obviously consider that request, but they do not need to accept, because you cannot ask an employee to work in excess of their contracted ordinary hours.
Okay. So is an employee who is on unpaid leave still eligible to receive JobKeeper payments?
On unpaid leave, yes, absolutely. An employee will not be eligible to receive JobKeeper payments where they are on a period of paid personal leave from the government. So if they're receiving the government paid parental leave scheme, then they won't be eligible to receive JobKeeper. The other circumstance where an employee unpaid leave won't be eligible for JobKeeper is when they're in receipt of workers' compensation and are totally incapacitated.
And I see in the media over the weekend that the government is already starting to modify the JobKeeper program, and whether it goes to September or is tapered for some particular industries is a moot point, I guess. But what happens to JobKeeper when my employees actually return to work?
When employees return to work,
Yeah.
they will continue to. So JobKeeper is a subsidy. So when your employees are ceasing the stand down and then reintegrating into the workforce, JobKeeper, if you're eligible, will continue to be paid to you as the business, as the employer, and then you use that to compensate for the employee's wages. So JobKeeper will continue until the government says that it's stopped. And at this stage, the date is on the 27th of September.
Okay, so just before we go to some of the questions coming through while we're on live here, Amanda, can you just explain and perhaps talk about, first of all, what the Rosato decision actually was, and also how that, what impact that may have on casual employment in our sector?
Yeah, absolutely. So the Rosato decision was another decision that caused shockwaves in the industry. But when you really look at the facts of the decision, which I'll briefly go through now, it's probably not unsurprising that the court found what they actually did find. So the Rosato decision was founded on a really specific set of circumstances. So for example, Mr. Rosato was purported to be a casual employee, but his timesheets were pre-populated. They were pre-filled out. So there was an ongoing expectation of work. His hours and days of work and hours of work were known to him in advance. Another factor that made this case, unusual in one sense, because it's not really indicative of casual employment, but then probably doesn't, when you learn to know what it is not unsurprising to see what the court found, and as it did find, is that he was purported to be a casual employee. We all know casual employees are able to reject and accept shifts as they like. Mr. Rosato, in theory, was allowed to reject and accept shifts, but in reality wasn't, because if he did reject a shift, then there were consequences which flew from that. So it's not unsurprising. What this means, though, however, is that you must be really, really vigilant as to the structure of your casual employees. Make sure that rosters are not pre-done in advance or too much in advance. Mr. Rosato's timesheets were done back from January in the start of the year. So make sure that it's not done too much in advance. Make sure their hours are sporadic and irregular, and make sure that there's not some sort of strict pattern of work. Ensure that the contract of employment has an appropriately worded offset clause. Ensure that the pay slips have a separate identifiable casual loading amount. All these little things will put you in good stead to ensure that your casuals are actually casual employment. So I don't want this to scare you. The Rosato and Skeen decision, as I said, was founded on a really particular set of circumstances. And we also need to bear in mind that these were cases of employees in the mining industry. So the mining industry are extreme examples of where work, by virtue of the nature of the industry, work does need to be set up in advance and pre-known weeks, months, and sometimes years into the future. In this industry, I think it's much easier if you adhere to the other factors of what a true casual is, to ensure that you are not subject to the Rosato decision.
Thanks, man. Now, I've just got a couple of questions come through live here. So I have an apprentice employee who I cannot give him his hours due to the fact we're not up to full capacity. Can I get him doing another role, such as cleaning, so he gets his required 15 hours?
Yeah, absolutely. So if you're JobKeeper qualified, one of the JobKeeper directions that you can give to your employees, if they are an eligible employee, is the direction rather, to have them work different duties. So as long as it's within their skill and competency set and it's safe for them to perform, then yes, you can.
And that's going to be a really important question as we come out of COVID, to be quite honest, because many of the staff employed in gyms are going to be required to, participate in cleaning, hygiene, sanitation exercises to make sure those gyms are clean. So basically what you're saying is, provided that it is within their capacity and not outside of their skill set, etc., it is not unreasonable for an employer to ask a PT or whatever to actually, in their downtime or spare time, to actually be cleaning equipment and so on.
Absolutely. As long as exactly what you said, they are qualified to perform the role, it is safe, it is a reasonable direction, it's within your business's operations, which cleaning the equipment is most certainly is within your business's operation, you absolutely can utilise that JobKeeper direction.
Okay, and just for those listening, from some personal experience, you may need to actually train and demonstrate and show your staff how to clean equipment, because I've seen from personal experience in the gym I go to, some less than desirable cleaning routines being put into play by staff that aren't qualified cleaners, but probably because they haven't been shown or instructed or demonstrated how to do it. So if you're going to ask your staff to do it, please make sure you demonstrate, make sure they understand totally what is expected of them, and make sure they follow through with that. Okay, this is from an employee, I think, Amanda. If an employer is not following precautions, I'm assuming COVID safe precautions, what can the employee do?
In the first instance, I would raise that directly with the employer and try to have a conversation at ground level to see what the issue is. They may be unaware that there is a certain procedure that they're failing to follow. If it's in relation to the JobKeeper scheme, and their direction to direct you to work alternative shifts or duties or days, then you are able to, in that instance, raise a JobKeeper dispute with the Fair Work Commission.
Okay, so just to take that to its next step, I guess, there may be some employers out there who like to tell their members, their clients and their staff that they are undertaking COVID safe precautions, but they clearly aren't. What rights does an employee have to not go back to work or whatever because they do not believe it's a safe environment because that manager hasn't been actually undertaking those protocols?
Yeah, I guess, as I said, have that conversation with the employee, and if you do genuinely feel unsafe and they're not following precautions, then you simply don't go to work, because it's the primary obligation of any employer to ensure that you attend work and that it's a healthy and safe environment. And if you do not feel that for certain genuine reasons, and you have evidence to that effect, then you'd be saying that you're not coming to work until that is rectified, and you have that discussion with them. Okay,
just a question here. What about contractors on JobKeeper? Do the comments you've been making earlier apply to them as well?
Contractors are very, very different. So unfortunately, I don't have any advice or further commentary to make. You'll probably need to seek separate legal advice in relation to contractors on JobKeeper.
Okay, we may be able to follow up on that separately. So this question starts off with, does this make sense? Question mark. All my staff did not qualify for JobKeeper because I still received a personal management fee from local government to manage their centres even though closed. This goes to insurance, utilities and maintenance. This management fee meant I did not drop down by 30%, that'd be revenue. It all got so confusing and we gave up. I'm not quite sure if there's a question there or not. Perhaps the author of that question might be able to clarify that a bit. I'm not quite sure what is being asked there. Okay, the next question. If I'm qualified and am receiving JobKeeper, what happens if my turnover goes over the reduced percentage allowance, i.e. business improves?
Yeah, really good question. Currently, as we're probably all aware, this scheme, it was ever evolving and there was changes made up until the last minute. So we're unsure if changes may continue while the scheme continues, but as it stands at the moment, once you're in, you're in. So once you've passed the test and you've dropped the 30% and you're in, and then perhaps your business increases above the 30% threshold in later months, as it stands at the moment, is that you do not need to retest yourself. So once you're in, and you will be eligible for the JobKeeper payments.
And I think that's probably going to be, hopefully, many of our gyms that are now reopening will actually get back to their normal income. And what you're saying is that they retain JobKeeper at this stage until the 27th or thereabouts in September, unless the government makes a change or introduces some sort of audit process to validate that.
Yeah, correct. Yeah.
Okay. All right. There's no more questions that have come through here. Is there any other general advice that you would, from your experience, Amanda, want to pass on to both employers and employees in this interesting times we're operating in?
Yeah, very, very interesting times that we're operating in. It seems like my experience is that things are starting to settle down. Your major, for employers I'm talking to at the moment, hurdle will be having your employees return into the workforce. You might get some employees who will try to not come back to work and still retain the JobKeeper. We've been seeing a lot of that happen. Some of the reasons why are actually genuine, which is why, as I was trying to make really clear before, we cannot jump to conclusions and we do need to assess these situations on a case-by-case basis. But where the reasons are not genuine and it's an attempt to perhaps extort this the system, then please ring the line and we're able to provide you some more practical advice moving forward on a case-by-case basis. And then on the other side of that, to the employees now, there will be times, hopefully not, fingers crossed, not at all, but there may be times that you do genuinely feel unsafe and that you are receiving some conflict or friction with your employer who is not adhering to safety protocols, or maybe they are and maybe you're just a vulnerable person or have care of a vulnerable person. And if you need further advice in relation to that, again, please call the line. Happy to help out and go through your individual circumstances separately.
So, Amanda, is there some general principles of duty of care that would apply? You may have just answered this question, but I mean, as I understand it, an employer has a duty of care to provide a safe workplace for their employees and potentially for their clients and all that sort of gear as well. Has that, what's the word I'm thinking of, has the importance or the emphasis on duty of care increased at all in this current situation, or has it always been there?
It's always been there. It's probably more of the, in our forefront of our minds now because there's this active deadly virus, out there. So we're more aware of it. We're talking about it more, but the primary duty of care to provide employees with a safe and healthy work environment has absolutely always been there, and that hasn't changed.
Okay, well, there's no more questions come through, so I think you might be free to go, Amanda. Thank you for your wisdom and your insight during this afternoon's session.
No worries. Thank you, everyone.
We appreciate that. Thank you.
Thanks, Barry.
Just before we do wind up, folks, some of you have been asking to email to me this morning about what's the situation in New South Wales. As you know, the Premier here, or not the Premier, the Deputy Premier announced last Monday that gyms are going to be opening in New South Wales from next Saturday. The guidelines they gave us on the press release that John Barilaro released, which came down to 10 per class, 100 per facility, and that's as far as it went. And we have been trying to get from the New South Wales Department of Health and everybody else in New South Wales government what that actually might mean, bearing in mind that you're going to be opening up in a little over 3 days' time. To date, we haven't actually had any clarification that I'm comfortable to actually share with you because I don't want to confuse you. I don't want you to start thinking you're going to be operating your business on Saturday under a certain regime and it actually isn't quite what it works out to be. So I would advise that you keep monitoring our website, our Facebook for the most recent and up-to-date information. I apologise, we can't get any more out of the New South Wales government. As you know, they were the last state to actually announce reopenings. And surprisingly or not surprisingly, they are also not quite organised in terms of working with us as to what those openings may be. So at the moment, all we know is 10 people per class. What constitutes a class is we are unsure of, whether it needs to be a physically isolated space or whatever, and up to 100 in a gym, what that might mean as well. So we are trying to find information. Maybe we'll get something through this afternoon but please keep checking back onto our website to make sure that you have the most up-to-date information. Now, next week when we do this session, hopefully we'll have more information around Australia, and the last state we'll be waiting for to actually reopen will be Victoria. And maybe we'll be able to give you some updates on Victoria as well. And I certainly hope we can give you some updates on New South Wales, given the fact you would have been open for 3 days already. So thanks for viewing in, and I look forward to touching base with you again next week. Thank you. Okay. Last.